Hello, Lyric Armstrong here, your real estate agent and advocate. Thank you to those who saw the last video of Jay-Z being added to Puff Daddy's lawsuit claims, or the lawsuit claims involving Jane Doe versus Puffy. So this particular sorry, still emotional. Anyway, this particular video is going to be dedicated to more of what we usually talk about on this channel, which is real estate. We're going to go into Judge Simpson's courthouse. So if you're interested in things that are entertainment specific, this is what we usually talk about. So that's not what we're going to do today. Today, we're going to get into landlord tenancy, Judge Simpson, and we're going to thank our very own Old Squishy Garden. Thank you so much, because it's brought to us by his channel. Let's get in here. Okay, so we're here. Go to his channel. Make sure you subscribe and like the video for him. Thank you. We've done the same. Now let's get into court. Judge Simpson, we're ready for court.
Hang on. Hold on, counsel.
Oh,
I'm not going to worry about it
we got to hold on.
at this point. I'm just trying to get through these. Come on.
He's not talking to us, obviously.
Your name?
Pamela Peel.
All right. Miss Gerler here?
She's on the phone.
No, she's on the...
I do not know how this got muted again, Your Honor. I believed I was on unmute. I have been present.
You're good right now.
Okay.
All right. Where are you folks in regard to this case? Did you receive a copy of her answer?
Yes, I did. Yes, I received it on the 13th. So I'm the owner of the home at First Way, Dexter, Michigan, where the defendant is now occupying the first floor. I'm very nervous in this setting, so that's why I wrote everything.
That's okay. Me too. Go ahead.
Okay. I'm seeking possession of my property, and I want the defendant to move out immediately. We have no lease on September 20.
Okay, so she is giving the judge a reason why she's going through her written statement. Usually any testimony or preference to the court, you try to do it just in natural conversation, because you're telling the facts of the matter and you don't want to be reading from it, because it'd be questionable as to your actual memory towards the facts. So she's like, Judge, please forgive me. I've written it down because I'm nervous. He's like, no problem. Just tell me what it is.
23rd, 2021, the defendant and I made a month-to-month verbal rental agreement, and she agreed to pay $995 a month.
So verbal agreements, verbal contracts, are they held up in court? Yes, they are. Harder to prove because terms can get fuzzy. It depends on how you got to look at it differently. So a lot of times what will happen is you have one person say, this was our terms, this is our agreement. And another person say, well, no, I agreed to one part of that, but not the whole. And then you have to show, yes, they did agree to the whole, because this is what they did. This is what their actions did to support. In fact, we had a verbal agreement. It's harder to prove than when you have a written agreement. So try to write your agreements down, but don't let someone tell you that you can't fight for oral agreement in court. Yes, you can. Case in point, here's one.
On the first day of each month following the first payment. On October 4th of this year, I gave the defendant the proper 30-day notice demanding possession of my property because of non-payment of rent.
Well, okay, let me stop you there.
Two separate things.
A 30-day can't be the subject of a non-payment of rent act.
The owner of the...
Yeah, let's talk about that just a little bit. Non-payment of rent is one avenue of restoration. You're saying they haven't paid, make them pay. They pay, they still keep possession, right? So that's non-payment. 30-day notice is, I don't care if you paid or you haven't paid, get out, because I want possession back. It doesn't mean it's a mean way. It could very well be that the lease is up, you're on 30-day notice, 30-day cycle, month to month, and you have to give them notice that you want possession of the place back. You can want possession back because your daughter got a divorce, your son got a divorce, and they need to live there, or you want any other family member to live there, or in fact you want to do renovations and sell it, or you just want them out because you want them out. You don't necessarily have to have reason. It's just you have to give proper notice. So those really are two separate lanes, and the court needs to know, what is it you want me to do? You want me to evict them, or do you want them to pay? And that's his point. Like, what do you want done?
The home at First Way, Dexter, Michigan, where the defendant is now occupying the first floor. I'm very nervous in this setting, so that's why I wrote everything.
That's okay. Me too. Go ahead.
Oh, I went back. I'm sorry.
I'm seeking possession of my property, and I want the defendant to move out immediately. We have no lease. On September 23rd, 2021, the defendant and I made a month-to-month verbal rental agreement, and she agreed to pay $995 a month.
And for those of you who have leases, when the lease rolls out, then you go into a month-to-month automatically. In most states, that could very well be not the case in other states, but the states I operate out of, that's the way it is. It's month-to-month. So double check with your lawyers and stuff. But when it's month-to-month automatically, that means you haven't done anything to make it month-to-month, or you could have a month-to-month lease. All depends, because you can determine the terms you guys want to agree to. You can agree to a 6-month lease, a 3-month lease, a month-to-month lease, or a year-to-year lease, whatever the case. But once you come out of the lease, it defaults into a month-to-month lease, regardless of what you've written up or not. FYI.
On the first day of each month, following the first payment.
Mm-hmm. Okay.
On October 4th of this year, I gave the defendant the proper 30-day notice demanding possession of my property because of non-payment of rent.
Well, okay, let me stop you there.
Okay.
A 30-day can't be the subject of a non-payment of rent action.
Mm-hmm.
Okay. So,
All right. Do you want her to move, or are you just terminating her tenancy? I mean, are you terminating her tenancy and want her to move, or do you want her to pay you?
I want her to move, and I want to also have a money judgment. So I can't do that?
Yes, you can do that.
Okay, that's what I want.
Okay. Go ahead.
Yeah, and I'm seeking a money judgment from the court for all back that she owes me as of December 1st, 2023, which is $11,995 plus court costs $215 and service fee of $68.
So how much is your
So the total
claim?
money judgment requested from the court is $12,278.
How many months did she say she was behind?
All right, Ms. Gerler, what do you have to say to that?
Michigan.
Your Honor, when I first moved in, it was to be a temporary arrangement. I had another place lined up that did not end up happen. I have attempted along the way to give Ms. Peel, the plaintiff, money. I became extremely ill with COVID, which I have long COVID, along with 2 other disabilities. When I became behind in rent because of illness and sought help from local agencies, the plaintiff was offered money from Faith in Action, and she declined those monies.
Why?
And there were other monies from other agencies that would have been available that would have satisfied my.
Yeah. So, how about you? Squishy makes a good point. Was the offer in regards to there would be no balance? They would pay a portion and the balance would be forgiven? Yeah, you don't have to agree if those are the terms. You don't have to agree that you're going to accept partial payment. If you want full payment, you want full payment. And that probably is the reason, because I can't understand why someone would say no. It must be something to that effect, like you're trying to waive off the rest of your rent versus you still maintain responsibility for the balance.
Arrearages at that time,
money, right?
of $2,985. time
you owed
would have been
11,000?
available that would have satisfied my arrearages at that time of $2,985.
Okay, so she's trying to say that it would have satisfied what she owed, basically $3,000 at that time. And that was some time ago because she's up to 11,000 now. Huh, we'll see.
Defining
I don't know anybody that's going to say no to the money that's owed to them. There must be a discrepancy in the cost of owing, because if you owe 3,000, they're going to pay 3,000. Why would she?
those monies led me to believe that she simply wanted me to move out. So I tried to.
Now that's an excuse if I ever heard one. She didn't take the money from them, so she must don't want me to pay anything. She just wants me to move. So I don't owe anything.
Start packing possessions, became ill with COVID again. I have, in the court documents, outlined to you the many times since then that I have been afflicted with every COVID variant. I already have a serious extreme condition of electrohypersensitivity that I cannot easily find a place to live. I cannot live in group settings, be exposed to Wi-Fi, wireless meters, be near cell towers. I need a rural environment. I no longer have a vehicle. I cannot.
Wait a minute, is that a thing? Like you have a body illness with your body that you can't be near cell towers or Wi-Fi? You have to live out in the wilderness? I'm not saying it's not a thing, but tell me, is it a thing? And if so, how the heck? I mean, people do live off the grid, but for most intents purposes, if you're living near a hospital or in a community setting, you have those things around. So how you must? I'm interested. How far away do you have to be from the tower? Does the tower have to be a certain mileage away, or you just really can't be near them at all? Like you need to be for real away, like 20 miles or more, or 3 miles good.
Environment. I no longer have a vehicle. I cannot environment.
To a cell phone.
I no longer have a vehicle. I cannot
Netflix.
Use cell phones, smartphones, computers due to my.
You're not a child, you're a man. So stop wearing so many layers to go outside and get the Bearskin Tactical Hoodie 4.0. The 10-pocket.
Electrohypersensitivity, and I thank the court for granting.
All right, I hope you can still hear me. I had things happen, phone calls and all, right? Okay, let's get back into it.
Appointment at the last minute since I was not.
Oh, wait. So she has all these things. She can't use a smartphone. So she must be using some other kind of phone because she's on the phone. So phones are not all out. It's just what landlines are okay. I don't know. Tell me, educate me. I don't know what this is.
Electrohypersensitivity, and I thank the court for granting this Zoom appointment at the last minute since I was not supplied the forms necessary in the personal and mailing service I received, and was actually waiting because in our December 1st hearing with Judge Barr, he informed the plaintiff that she had filed incorrect paperwork and needed to refile. So I have been waiting for that paperwork to come, which I don't know if something changed and was not necessary. But
what incorrect paperwork? I don't have a notice to that.
Well, and that's whatever.
You have to be careful too about correct paperwork. Sometimes we want to show the judge that we are somehow doing something right, even though we didn't get the proper information. When you start stating that improper paperwork or correct paperwork was not given, things were omitted, it's a problem. The judge has to look at it because you have to have notice. If you're there, then it shows that you had some type of notice, obviously, because you're there. But if you turn around and say in the notice there's deficiencies, then it can hinder the judge's ability to put an order through. So they have to make sure things are done in a certain timeline. So just be careful. Make sure you can prove what you say when you say the paperwork was incorrectly served.
Happened, Your Honor. That's what I heard in court, and I'm not privy to what happened thereafter. I am what I heard.
What
to that.
you talking about?
Well, and that's whatever happened, Your Honor. That's what I heard in court, and I'm not privy to what happened thereafter. I am chronically ill, Your Honor.
We got the chronicle illness. Can you tell us what you're talking about with this paperwork? I don't get it. What is she talking about? Let me go back. Oh, what does Squishy say? Okay. Old Squishy Garden says, so basically you looked for every excuse in the book to do nothing about moving and then expect the court to bail you out. Okay. All right. I guess so. I don't know.
What incorrect paperwork? I don't have a notice to that.
Well, and that's whatever happened, Your Honor. That's what I heard in court, and I'm not privy to what happened thereafter. I am chronically ill, Your Honor. When I get well.
Ma'am, hold on.
Okay, hold on. Squishy got something else to say. One thing for darn sure, our society does not have a great support infrastructure for folks who are chronically ill and don't have support. He must be being facetious because we do have support for that.
Yes, ma'am.
I spoke with my attorney counsel yesterday, and she said my paperwork was fine. I think it was just not clear to Judge Barr what I wanted because I didn't know how to present my case.
Oh, a different.
So,
well,
okay.
But
yeah, I actually see what Judge Barr is saying right now.
Okay.
Well, you filed 2 different notices. That's why.
Mm-hmm.
I got it. It's fine.
Okay.
I think. Hold on.
So 2 different notices could be problematic because it's like, what do you want the court to do? What do you want the court to respond to order, to make judgment against? And that was kind of how she opened up. She gave 2 different lanes. So she actually did do 2 different notices. That may be the confusion. I don't know what the defense is saying. Tenant's probably saying, I heard the tenant say, I didn't get paperwork that allows me to appear by Zoom, which usually comes from the court clerk. That's what I heard, but maybe I'm missing it. I don't know what she's talking about.
That's not that one. Right. You filed 2 different ones, but you got, it appears to me, the correct paperwork. Right.
And that's another thing. This is why you need attorneys for representation. She didn't say the paperwork itself was incorrect. She said there was something she didn't receive in the paperwork or attached to the paperwork. And to me, it sounded like she was saying she didn't receive the information on how she can appear in court virtually. Because in the packaging of service, you serve your documents as the plaintiff, and then the court, when you file it, the court clerk will say, okay, here's these other documents that go with it. And some of those documents could be required mediation. It could be select for arbitration versus going to court. It could be documents that say, here's how you apply to appear virtually. So that's what I thought she was saying, that particular document that tells you how you appear virtually was missing, and she was thanking the court for allowing her to appear virtually anyhow because she didn't know, and she missed something else because she wasn't able to come to court due to her illnesses. That's the way I heard it. I don't know if that's what she said, but that's what I heard.
Your Honor, just to respond, that's what I heard from the judge. And my legal
but
counsel,
this is another judge saying that that's wrong. It's correct.
and that's fine. I have no problem, but I was waiting on that paperwork. I know that the plaintiff.
Was she waiting on a minute order? What paperwork are you working? I want paperwork, Your Honor.
But I was waiting on that paperwork. I know that the plaintiff is someone who tries to do things appropriately, but what did not happen appropriately with this home that has been a long time rental is that there is no certificate of compliance on file with the township. And the
so when are you?
So when you're moving, boo. Whoa. So there's no certificate of compliance, meaning that you don't have the right to either one, it doesn't have the clearance of someone living in the house, period, or that you don't have the clearance to rent it out. I mean, so are you trying to get her in trouble? Like, just get out. Why are you there? If it's unsafe, why are you there?
Compliance on file with the township and the
Okay, so
advocation.
when are you going to move then?
When are you moving?
Your Honor, I have.
What she says never sounds like. Listen, if you haven't checked out Oh Squishy Gardens channel, you should check it out. He doesn't interrupt like I do. If you hate the sound of my voice, hey, here's an option for you. But this is really funny to me. He has a good, funny way of looking at things, and yeah, never sounds like her answer. I agree. She doesn't want to move. It's not compliant, meaning, you know, shouldn't live there, but I don't want to move.
Had to deal with all the demands of the court, so I cannot explore that yet because I was required to.
Blaming the court that the judge just told you was not the issue. Yeah, blame any court. And I don't know if you're trying to pin one judge against another, but you're not going to do it. They're really going to stand for each other at the end of the day. And then you're going to turn around and blame the court. For what? For what? How long have you been there before it just went to court?
I cannot explore that yet because I
cannot explore that. You can't explore moving?
Required to apply for
you gotta get out.
SER with the DHS, which was declined. I have contacted every agency available to me thus far.
Ma'am, do you understand she doesn't want you to pay rent and stay? She wants you to leave.
I understand that, sir, but to comply with the court and the paperwork required for this hearing, DHS, that's where I have put my first attentions. I have been packing and moving things out of the house, which they have witnessed, but because of my extreme sensitivities, it is not easy for me to find a place where I can live safely. I have just recovered from my last.
So here's the thing that drives me insane, and I don't want to be insensitive. Y'all know I'm a landlord, so you know I love tenants. I especially love my tenants because they great. But some tenants just don't make no sense. Listen, if you were paying your rent, I'm sure she wouldn't have a problem, right, with you being there. However, this tenant has already testified to the fact that her being there was only supposed to be temporary. So she realizes that she's there longer than she was supposed to be. And then on top of that, she's not paying. She paid something, not paying now. So, you know, why is that the landlord's fault that you haven't found or secured another place, especially when you're not paying for the place you're in? It doesn't work that way. And, you know, if someone was doing it to you, if you were a tenant and you happened to be subleasing a room or had a roommate and they weren't paying you, you would want them to get out. And you don't want to hear about they can't find a new place. You're $11,000 in the hole. What does it matter that you can't find a new place? That's not her fault. That's not her fault. It's not her problem. That's yours as a grown adult.
Last bout with COVID, which has severely impacted me for the.
I'm sorry if I'm being insensitive, but to me, she's making a lot of unnecessary excuses versus saying, can I have 2 months? Can I have this amount of time to get out? She would be better negotiating her time than sitting up here giving all these excuses.
The last 4 years and created these issues. And I have also.
Ma'am, I understand all of that. The question becomes, when can you move?
Love this judge. Love Judge Simpson and his rulings. Thank you. Bring it down to the core. When are you moving? And I don't know if people, I guess they're just trying to get sympathy. And they're used to getting sympathy probably from the landlord. And that was another thing that really gets underneath my skin. We have a lot of public opinion that landlords are gougers or that landlords are smug, what do you call it? Smug lords or what it's called. Whatever the term is, get it. Just, you know, that they bad. Most of the landlords I know are caring. They don't go up high on the rent. They keep it where you can pay. They try to keep, we try to keep our tenants that we want to be long-term tenants. We try to keep them there, especially when they're taking good care of the place and they're not causing troubles and they're paying on time. So we don't go all out on the rent. We don't go up just $1 million. We don't do $1,000 tax. Now there are some who do, but the most of the ones I know do not. And so we take offense to the fact that landlords are, some type of gouging coming. It's a business. It's a business, and the business is staying with the market. The business is getting enough money to pay the bills. The business is making a profit. So, you pay that extra amount for the eggs. Eggs don't went up, God knows how much, like 3 times, double time. Like eggs are expensive right now. You pay for that, right? It's a business. So I don't know. For me, I have a bias because, like I said, I want everyone to own. I think you should have ownership. Rent as long as you have to, but get yourself some ownership. So when you get ownership, then you can use that to get more ownership and to help build a legacy for your family. But this lady is like, I don't know. She just wants to stay there forever, ever. Like, why do you think that that's okay? Why does the landlord have to take it? Why does she got to take it on her backside, but you can't take it on yours?
The question becomes, when can you move?
When can you move? That's the question. That's the only question.
That is a question mark to you and me both, Your Honor. I do not.
Listen, you shall move with by the end of the month. Like, don't give it to him. It's not his question, because he's trying to help you out. Don't get brazen. He's like, listen, give me a date that I can work with. So when I put this order down, you can get out on a certain date. But that's a question to me and you, Your Honor, when I can move. You right. Bye. End of the month.
Not know. I have nowhere to go. I am solo in this world. I have.
Squishy says, laughing my tail off. I don't know. So I need you to just give me an open-ended rent-free lease in your decision. Okay, Your Honor, thank you so much. Like, no, that's not gonna happen.
No vehicle. My car broke down June of 2022. And
worse. Just give it time.
My situation
like
is not a good one because of chronic illness.
Everybody
my energy is not
everybody.
reliable, and sometimes 12 hours in the bed.
Property.
Okay, ma'am, I can appreciate all of that. But you also have to understand that the landlord is entitled to her premises back.
I understand that they request their premises.
Why they? I know that this is just the security. He's just there, but he right when Judge says that the camera turns to him and makes it look like he's side eyeing, like, yeah, ma'am, don't you know? Don't you know you gotta go? Look. That's just messed up. He was trying to cover the bases, make sure the grounds are secure. But as if someone was scripting this, they panned to him and was like, hey, what you say, man? And he's like, yeah, I don't know what her problem is. She knows she got to pay rent to live there, right?
I understand that they request their premises back. And
you have no
have an appointment with Hawk on Monday. To what degree that will help, I do not know at this point.
No, because I think Hawk...
In a world where the elite sip water priced like liquid gold, our guests tonight are expecting the cream de la cream of high...
I have been unable to find...
Hawk, if I remember correctly, only helps when you're still in the place. So it's like they are a entity that will pay back rent as long as you're still going to be living there. So that the landlord doesn't kick you out, so that you can maintain possession. This landlord is like, I want my place back. I want possession. You owe me money, so I want the judgment for what you owe me, but my goal is my possession. So I don't think Hawk would be a remedy at all, but I could be wrong in what Hawk does, but I think that's
assistance from anybody because they say I am not sustainable because I am now forced to live only on my Social Security income, the
Okay.
house line.
All right. Okay, ma'am. Here's what I'm going to do.
So Squishy said, well, she might have wore out her welcome elsewhere. Not necessarily, could be, could not be, but also if her statements are accurate that her living situation has to be highly controlled, and most people are living with certain comforts of technology, right? Most of us have Wi-Fi in our home. Most of us are dealing with our cell phones that are smartphones, and so if those particular items are physically hurting her living with someone else who enjoys those items would be impossible. So that it may not be that she wore out her welcome versus they don't have something that they could offer to her.
You, because this has got to.
You can't even live in a shelter.
I understand the difficulties that you're telling.
If that's.
I also understand that the landlord needs to resolve that. So I'm going to set this for a trial. You've raised some issues in your answer, but I'm going to set it for now. Yes, ma'am.
When I talked to my attorney, she said that there is no requirement for the compliance regulations in Webster Township where I live. And she's an attorney from Dexter. So.
Oh, they know more. They know more than us here, us other country folk from Pittsfield, or what?
I guess.
Yeah, I agree with Squishy. Like, don't interject. Let the defendant, let the tenant dig her own grave in that regard. Don't start. Never argue the law with the judge, okay? And don't give third person opinion. My attorney said, because here's another thing. Your attorney might have said that and you misunderstood what they meant, or they may have been responding to something else. You don't know what their thought process is. So if you're going to have an attorney represent their thoughts and their arguments, they need to be on the case representing their thoughts and arguments. They need to actually be appearing before the judge so they can completely give the judge their explanation and understanding, and not you try to translate it. So don't do that. And furthermore, say nothing because you're winning. It don't feel like it because the judge is like, we're gonna set this for trial, but you're winning because her arguments are like, okay, so when can you move? The thing that may be concerning is if it's not clear for occupancy. That's the only thing I guess the judge is working off of. So legally, could you in fact charge rent for the months that you're charging it? And since you want a financial judgment against her relative to those months of rent, he has to now do a trial to find out if the place in fact was legally rentable. That's what it sounds like the question is the legal question is that he wants a trial for. But so what? She has to leave. Like, he's going to order her to get out. He's already expressed that. So don't dig your hole. And I know that you feel like, oh no, I want her out tomorrow. I don't want to wait another day. Be patient. Patience is a virtue, but it does pay off to be patient. When you rush things, you can get a very rushed result that is not beneficial to you. Whereas if you're patient and allow this to take its course, you can get a favorable result that is beneficial.
I don't know.
You don't know.
That's what she said.
So no talking.
Is that correct?
What?
That's what she said.
I don't know. I guess she's from Dexter, so she knows more than us. We're just little country judges up here. Ma'am.
I actually called the zoning person too.
And she said, yeah, probably she agreed.
I'm having difficulty hearing, Your Honor. Could that be repeated?
No.
No. Okay.
No repeating.
She went to Webster Township. The issue regarding the certificate of occupancy, it really isn't an issue because they don't require it for rental properties in Webster Township. That's the long and short of it.
I would like to know then why Legal Services of South Central Michigan gave me this form and checked
Okay,
it out.
ma'am,
They must
I
have
don't
obviously
know. You
researched
guys keep talking about lawyers. I've not met them. I don't know.
Right?
it.
All I
have not
know,
met
all I
them.
know is this. You two are in front of me arguing a case.
That's
You have one
for
position,
trial.
plaintiff has another position.
Mhm.
So here's what I'm gonna do. I'm gonna set this matter for non-jury trial. It will be in person.
Your Honor, that I hope you realize is not possible for me. I'm even being harmed waiting for 2.5 hours on my cell phone, which is on speaker
Then,
remote
ma'am,
from me.
then I don't.
How do you expect court to be court when your position cannot be presented? Like, here's the thing. If someone files a complaint and you file an answer, you're agreeing to go to court. I know it doesn't sound like that, but in essence it is, because now you have answered, you have an opposing position. If you agree to a person's complaint, then you settle it. You just go, oh, okay, I got your court order. Come on, let's settle out of court because I don't want to go to court. Let's settle it. And you file an agreement of settlement. I'm not file, but you sign, you negotiate an agreement of settlement with the other side. It could be filed with the court, and then they can pull a default judgment based upon the fact that you settled without prejudice. In case if you don't comply with the settlement, then they can go back to court. But when you answer a complaint, this means you have an opposition, you have an opposing side. And so therefore you need the judge, the court, to figure out what's legal, what's not legal, what's fair, come to resolution. You need the judge's opinion, you need the judge to intervene, the court to intervene. So when you are requiring the court to intervene, you need to be able to present evidence. You know, that's what trial is about. You need to be testimony, that's evidence. You need to come to court. And I think people are used to Zoom, and I love Zoom court. Like, hey, I'm loving it, right? We're here, but we're used to Zoom court that we think we have a right to Zoom court. Zoom court is a privilege. Consequently, for all those who are, having the benefit of Zoom court, let me tell you, it's not all across the nation. It's only select places that are allowing Zoom court. It is a privilege. And even having Zoom court in Michigan is still a privilege. They can say, no Zoom court, you have to come in person. Another thing is the woman's on Zoom. We don't even see her face. I'm surprised that the judge is allowing her to appear without showing her face, unless he sees it and we don't. But a lot of times they won't allow for that because you have to present to the court. They have to verify you as a person. You attest that you're the person that's talking. They also have to verify that there's no other person talking in your ear and coercing you or coaxing you into saying a certain thing. So
I don't know how I'm going to,
which is on speaker remote from me.
Then I don't know how I'm going to get you into court.
Yeah. Like how? How do you live life? How do you go to the grocery store?
How is is it not possible for me to continue in this manner, sir? I have been before you to establish the severity of my condition. I become debilitated, incapacitated, ill. I lived in the basement of my prior home for 7 months because of radiation poisoning, and by necessity, where your court is located, there are many electronic communication requirements for police, fire, the cell tower, Wi-Fi for the buildings.
A wet blanket? Buy a cheap space blanket or a few rolls of industrial grade tin foil and wrap it. Is that real squishy? Would you really have to buy that to go out into the world? Is that what you do? You have what's a space? Oh, like an outer space blanket? That would be weird if she came into court like that. I hope they would. I mean, if you have to, you have to. But we really would need some sensitivity training because a lot of people, such as myself, who are ignorant to this matter, would think you were cuckoo for Cocoa Puffs walking in with a space blanket and wrapped up in tinfoil.
I will literally fry and be unable to move. That's why I couldn't
fry
today.
You would fry? So it's a burning sensation that happens? Hey, fam, community, in the comment section, what is this she's talking about? Is this real? Is this a real physical situation? If so, how do you live? What do you do? How do you get your groceries? How do you go to the DMV? She said her car is broken, so she definitely had a license at one point. So how did you take your driver's license test? How do you function if you can't get into the community? Do you have to wear certain clothing? Is there like, is squishy on or something? Like what?
Unable to move. That's why I couldn't come today. This is not a fun scenario. And the landlords are well aware of my conditions. They had mitigated the house. They used Ethernet.
Bless Judge Simpson's soul. He's like, I'm trying to listen. Yeah.
All right, ma'am. All right, look. Do you have any problem if I hold a trial and she appears by Zoom?
I guess not. I've been without income for a long time, and my preference is
okay. Look, folks.
Yeah.
There are a lot of folks out there that
Everyone
are having a hard time, and I get it.
Yeah.
Okay, I have to deal with it every Friday. So I don't know that I can help you with any of that right now.
Right.
I'm just trying to set a trial date.
Right. He's not a medical
Do you have any objection to her? What?
Tomorrow, the sooner the better.
I'm not coming in on Saturday. I'm just, it's not happening.
How about Monday?
No. What? We can do when?
That's the thing. The plaintiff, the landlord is like, the homeowner is like, I want her out now. I don't want a trial. I want her out. She wants judgment for her to get out. And the judge is like, yeah, but we have a triable issue. So you'll hear this, oh, you didn't bring a triable issue. You didn't bring a triable issue, meaning that there's no trial that can solve the problem. So if all of her problems were her disability, that's not a triable issue. They couldn't solve that. But she is bringing up a claim that the property is being rented and it doesn't have clearance to be rented. It's not safe to be rented. It's not an occupancy. It doesn't have certificate of occupancy, meaning that it can be occupied by a person. Some new builds, when you purchase a new build, everyone loves new build. They still have to have a certificate of occupancy filed, and it proves that another person can live in it. That's important. So if you're buying a new build, one of the things that the lender, the bank, is going to ask for is a certificate of occupancy. They're going to pull it from the planning department, or they're going to ask for it from the construction builder or the owner of that property that's trying to sell it, because they want to make sure they can put a loan on this because it's been cleared for a person to occupy. So their argument in this case is there's no certificate of occupancy for this property, so you can't rent it out. So therefore you shouldn't be claiming monies from me because you're not supposed to be renting it in the first place. And this landlord is like, look, I just want her out. Get her out. And the judge is like, nope, we now have a triable issue, so we must go to court. We must have a trial. Got to now, because now we have.
What time? 1 o'clock on Wednesday? Oh no, I can't do 1 o'clock. What time seriously can I do? Non-jury trial, December 20th, 2023.
Oh, 23. We should be able to find
9 a.m.
9 a.m. Okay. And
you need to appear in person, ma'am. You can appear via Zoom.
And right here?
Absolutely, that's where I'll be.
Okay.
And if I don't get this docket done, I'll be still sitting here from this one.
All right, thank you.
Thank you.
Okay, thank you, Your Honor, for the accommodation for my disabilities. I appreciate your sensitivity to the matter and your humor.
Thank you, ma'am.
your humor. We all appreciate his humor. Surely we do. Okay, so something is wrong. I don't know what. Hold on. I haven't been doing good at cutting. There we go. Finally figured it out. I don't know what it was. I haven't been good at doing our edits. I'm sorry. But I'm just trying to get things done. So let's see if I can. Okay. I don't know why it keeps black.
I will sign off now.
Okay. Let's see if we can find. I don't know if we can find the next thing. Oh, Karen evicted. Law Talk with Mike. Law Talk with Mike has something about Karen was evicted. Gosh.
You want to know the key to fixing and flipping? Don't fix and flip. Instead, be the.
So Law Talk with Mike is another good channel that has some. Oh, Sovereign Citizen. Yeah. You got to pay your bills. I don't care what you call yourself. I don't care what your name is. You got to pay your bills. I wish I knew what the case number was for this. But anyway, so December 20th. The thing about Judge Simpson's court, however, is that I have so many things open. Is that I don't know if his court actually holds his cases that long. So I don't know if we're going to actually get resolution to what the trial was. Because his channel, this Judge Simpson TV channel, the videos, I don't think they go back that far, but we're going to see. It's 23, yeah. They don't. They go back like a month ago. So you have to catch it yourself. Let's see. What about old Squishy? So again, Old Squishy Garden Court Watch is the name of the channel that we were just watching. And wait. What is this? It was the one I was just watching. Hold on. Oh no, where is this? This is new.
That is very much.
Okay, I don't know if this is the same one. I'm hoping. I'm crossing my fingers. I hope it's the same case. But you know, we're just gonna have fun today. Like, let's just have fun. It may not be funny. This is
Peel versus Gerler.
I don't know if this is the case or not.
Ms. Gerler, are you there?
I am unmuted, Your Honor. This is Ms. Gerler, and my last three digits are 343.
Yes, ma'am.
Okay.
Are we on? This is set for non-jury trial. This was a termination action. Ms. Gerler, what's your defense to the termination? There's a month-to-month lease, correct?
Well, there was a change in agreement as well, Your Honor, and history and backstory that is very much applicable to this situation. I would like to first bring to your attention that I'm a lifelong, long-term renter. Resident.
That's a sound, I guess, on the tenant side. So sorry, guys. If it's in your ears, take it out because we usually keep the sound up. Yeah, we're up. We keep the sound as high as possible. So don't plug into your ears.
Essentially, longest term 13 years, and 8 years. Commercially, I leased an upstairs office at Nichols Arcade from Wilson White Management at that time for 15 years. I have never had a problem paying my bills or until COVID, and which I contracted in fall of 2019, which began a horrendous downhill slide of health, illness, income, and has basically rendered me indigent at age 68. I have tried to get help from agencies, and I have not even heard back from Hawk as to, after my appointment on Monday, as to, how things went. There are many issues beyond what is apparent on the ledger sheet. And when I initially agreed to move into this home, I had another one lined up as indicated previously in our hearing. I requested to stay only.
That is, okay, so the beginning of her testimony thus far, I don't even know if she was sworn in, but the beginning of her testimony so far is like, I have been a tenant. She's a lifelong tenant. I've been a tenant before. This is not my first, it's not my first place. I know rules. I know how to pay my bills. I am a responsible tenant. So happens that I was unable to stay responsible because of something unfortunate that happened to me. That's kind of where she's going with that. But the thing that is like the worst is to hear someone said, I could have dated this person. I could have lived over here. I could have, and I was, chosen for this place. You know what? You're not doing the landlord any favor by being the tenant. Okay? You're not. Like it's a mutual relationship. The landlord is providing you with a location. You're paying for the space for what you're renting, and so it's a mutual, give and take. But you are not doing a favor by living there, especially if you're not paying the rent.
3 months hearing.
So bad.
I requested to stay only 3 months. The plaintiff demanded 6 months because she needed me to watch her home.
Oh, wait. This is why the landlord is like, just get out, because it's so massively ungrateful to say, oh, I was only going to be there 3 months and she wanted me to be there 6 months. Yes, there are times when a landlord does not want a tenant only there for 30 days or only there for 60 days or only there, because they want to make sure that you're committed, that they don't want to have to keep getting a new person. Watch her home. Watch her home do what? Is it going to fly away if you don't stay there?
While she and her husband, the landlord, went to Florida for a very long vacation, over 6 weeks, I believe it was.
What does that have to do with
2020
being rentable or not?
Beginning of 2022.
So you were there. Okay, great.
Problems arose right at
Ma'am, can I just stop you one moment?
Absolutely.
All right. This is filed as a termination action. And fundamentally, the issue is going to be, because of there is no lease, is going to be, why shouldn't you move?
Your Honor, I've been before you previously, and I have 3 functional disabilities, electrohypersensitivity, which makes me incompatible with any of the wireless utility meters, internet, Wi-Fi, cell towers, etc. This home has also been mitigated for me with the acknowledgement and cooperation of the landlords, who years prior to my tenancy had replaced the utility meters with opt-out meters when I made them aware of all the issues of electromagnetic frequencies. They have Ethernet installed, and we had things mitigated to reduce the interference of electricity and wireless devices, including Stetzer filters in the plugs of electrical plugs of the home, which was also by verbal agreement. My loan to them on their above floors for the use of the landline digital cable phone, and that which has been denied to me and does not allow me to send more information to the court. My impression from the papers that I was.
So my husband just came home, sorry. But Judge Simpson is looking like he's praying. He's like, oh my God, can we get through this? Can we get through this? And I feel you, because what does that have to do with the price of tea in China? But okay. Okay,
was given, and as I indicated in the prior hearing, Judge Barr had said other ones needed to be entered that apparently were not needed. This is collection and termination. Had I had my phone line not turned off to me after I faxed in the confidential contact information requested by the court, I would have been able to send to you a letter from Ms. Peel that she wrote to the Department of Health and Human Services when I applied 3 years ago in 2020, stating that, you know, I was in dire financial circumstances and having problems paying rent with the prior landlord. I did not know at that time I had long COVID. It was also the plaintiff who did the research and informed me in late spring of 2022. But they have awareness of all my frailties and vulnerabilities, which they have not been honoring in any degree, and knowing how very difficult it is for me to find a safe place to live, and I'm going to have to move rurally. There is no housing, affordable senior housing, et cetera, I can be in because of everybody else's need for wireless devices, which are beyond hazardous to me.
Okay, I just wonder.
I suffer from.
I'm sorry. I just wonder though if this is legitimate and she's experiencing it, is there not a community of people that experience it? And if so, what do they do? Is everyone's only resort to live outside in the rural area? Do they have a community that lives together in the rural area? I don't know. I mean, it's a weird thing for me. I don't know.
Post-traumatic stress disorder from a car accident where when I requested aspirin, they wouldn't give it to me, but narcotics and opiates that were not compatible with me, and a closed head injury that was not diagnosed for 1.5 years. So I have 3 strikes against me just as a person functioning in the world with the long COVID, the electrohypersensitivity, and the PTSD. I have been subject to some very harsh, intrusive, invasive treatment as a tenant here for some time prior to these recent occurrences.
Are you worried that using your home address for business puts your
the assumption that one has of autonomy, privacy, and enjoyment of property when renting a property have also been denied me.
Okay, Ms. Gerler,
Yeah.
I'm going to stop you for a moment, okay?
Sure.
Those aren't a basis for me not to grant a judgment to the plaintiff, or at least possession. The issues that you're talking about may relate to their monetary claim, but as to the issue of possession, why shouldn't the landlord get their property back? Let me try to put it that way.
Your Honor, I was under the impression that Hawk and other agencies would be assisting me with the back rent so that I would have time to find a suitable place, because I will literally be on the street with my possessions. I would say that would be today's equivalent of delivering a head on a plate. I have nowhere to go. I have no vehicle. I live as a virtual shut-in with restrictions.
Okay, I understand that. Your name, ma'am?
Pamela Pia.
Okay. Ms. Peel, you've heard all those circumstances. You're aware with this defendant. How much time would you give her to vacate the premise?
Your Honor, I have asked her to pay up or move out since June of 2022. I am a very kind-hearted person.
And know that.
And
know that this is December 2023. So we're currently in the year of 2024, but this case is quoting December 2023. She's been there since June of 2022, being asked to move out. That's over a year. I wonder how they got to $11,000 in back rent. She's been there forever.
June of 2022. I am a very kind-hearted person. I was aware of circumstances. However, this whole thing, I'm in my 70s. I depend on my rent for paying my bills. And I kept asking her, hoping, praying that she would leave. And she was unable to do so. And I can no longer carry her on my back.
All right.
Literally.
I hear you, and I understand because of the pretrials in this case, where this case was. So how much is owing?
The amount of rent owing is $11,995. That's about
okay. Right. So the problem for both of you is, even if Ms. Gerler, and just listen to me, even if Hawk were to assist you, given what their maximum amounts that they would be able to assist, you'd still have to come up with $9,000. Okay? So there's part of that's the big issue. So when we get to that, pardon?
I
would Hawk assist? So let me know, because I said I think that you have to still be in the property. So would Hawk assist if you have to move out regardless of payment?
I would just need to inquire about those figures, because when I spoke with Autumn on Monday, she said that they had, I believe, a maximum of $5,000 they can issue. She was going to reach out again to Faith in Action for me, whose monies Ms. Peel, the plaintiff, declined.
What's the difference between $5,000 and $3,000? $2,000? It's not $9,000. So okay, so do you have $7,000 then? Is that what you're saying?
Whose monies Ms. Peel, the plaintiff, declined. And
okay, so that's $8,000. 8,000 minus 11,000. Okay, 3,000. Do you have $3,000? Like, to say that you could stack, and will Hawk and this other rent rescue, would they both contribute? Because some of them don't like to have multiple places. They're like, they'll contribute and that's it. But if you're getting help from somewhere else, then you don't need help from them, because they want to help many people, not just one person with all of their funds. So if they both contributed, you still would have money owed.
In July of 2022, and at that time, other affiliated agencies would have brought me current there was $2,985 owing, but because the plaintiff refused the offers of money. The other monies were not forthcoming. And the plaintiff also knows I have been sequentially ill on a regular basis. There's no soundproofing between the downstairs, upstairs. They hear me hack, cough.
What? Oh my God. Okay, even if she knows that you're ill, that means she's responsible to keep you in her house as if you were her child without paying rent forever. That's
Sneeze.
not reasonable.
Ma'am?
So
Ma'am,
I'm letting you
Ms.
know
Gerler,
it is illness, chronic illness. Yes.
Ms. Gerler,
That may be so.
whether it's 5,000, 3,000, we can get into that argument, but you'd still have to come up with the other 7,000 if it's 5,000. I mean, the problem is that those other amounts
Doesn't cure it. And they're not even on the table.
are going to be your difficulty.
They're not even on the table.
Your Honor, I don't believe that I should be culpable and responsible for the monies they declined in July 2022, the $2,985.
Well, she's doing math Olympics right now. So she's saying July 2022. Okay. So she's saying from July. So if you would have accepted the amount from the other location that would have brought me to current to July 2022, I don't owe that amount. Fine, but have you paid anything since then? Because it sounds like you haven't paid anything for over a year. So bye.
Which would knock the equivalent of $3,000 off of the total. When I spoke to Autumn, she said that she would also pursue with Faith in Action. I was denied by Department of Health and Human Services for reasons I don't know, because my mail is being held and I have not gotten that back to me. When you're only making $1,100 a month on Social Security, I don't know why I was denied, Your Honor. I can no longer work. I was self-employed.
I understand that, Ms. Gerler. Ms. Gerler, I understand all of that. But when we all boil it down, the reality is the funds aren't there. And so if the funds aren't there, what's really going to end up happening is you're going to have to move.
The argument that the place is hot.
As I see it, and I'm looking at the case, it isn't a matter of whether or not you will have to. It's a matter of when.
Mm-hmm. Yeah, when.
And I would ask that the landlords, knowing my circumstances and situation, please grant some lenience in this case, as they may be leaving at the end of the month to go on a 2-month Florida vacation.
Oh, she pissed.
I have tried even.
You see how she shifted in her chair? Like, you got to be effing kidding me, because I'm going on vacation. You got to stay in my house while I'm on vacation. What does her going on vacation for a couple months have to do with it? She's just trying to say, well, I don't know. It's maybe she's not trying to, but it feels like she's trying to say, oh, they don't really need the money because they still go on vacation, Your Honor. They can wait.
In this case, as they may be leaving at the end of the month to go on a 2-month Florida vacation. I have tried even to get people to help me pack, and people are not available due to our upcoming holiday. I am at this point.
Okay, Ms. Gerler.
Wait. What does Squishy say? Is anyone here still wondering why no one would make themselves available to help her? It's also not the court's problem. Like, that's not something the court can remedy. So
I am at.
Actually, what they could do is say, you get out and the landlord throw away the stuff you can't get packed up. Like, that could be a resolution. I don't know if you want that to be the resolution, but it could be. You can't just stay in a place because you don't have someone to pack you. That's not a good reason.
At this point.
Okay, Miss
I'm not
Gerler,
standing
let me
before
ask you
you.
this.
I'm weak.
Miss Gerler,
Yo, have you been injured in a recent car accident? If so, I want to give you a check like this for $50,000. All you need is 30.
in your mind, how much time do you need to move?
To be very
Not saying I'm going to
realistic,
give you
sir,
that much time. How much time? When could you be out?
to be realistic, sir, requiring the assistance and the fact that I may move very far away, I would likely need till the end of January because I have quite a bit of things to take with me.
So,
Okay, so you
if I remember correctly, this is sometime in December. So this is December 20th, right? Yeah, December 20th, 2023, that this hearing is supposed to be held on. So she needs the end of January. So the rest of December and the rest of January. And Squishy says, if I were the landlord, I would be jumping at the news if you've been trying to get rid of this woman for months. It's been like over a year. Because the woman said she tried to get rid of her in June 2022. So it's been over a year that she's been trying to get this woman out. Yeah, you can have till the end of January, maybe. I don't know. It's a long time, but whatever it takes to get you out.
need to the end of January.
Yes.
Give her 30 days.
Miss Peel, would you give her to the end of January to move?
He wants her out now.
I consult with my husband for 1 minute.
You look like the brain trust, but yeah, go ahead. You can go.
Yeah.
Would be willing to do January 15th.
Okay. So you won't do
Your Honor,
January.
that's not possible. I apologize
Miss
for
Gerler,
interrupting. It's not
Miss
possible,
Gerler,
sir. Yeah.
Don't interrupt.
Miss Gerler, hold on.
It is possible. It's just not going to be
Anybody have anything else to say
possible based upon your desire.
before I give you my ruling?
Your Honor, if there was anything else beyond hold on, I did not hear it. This is.
No, okay. I was just asking if anybody else wanted to say anything else before I issue my ruling.
Your Honor, I would like to say, if it is possible, they hold $995 in as a security deposit, with which they could keep for the month of January if I were allowed to stay. And of course, we'll continue to look for additional.
Wait a minute. The security deposit that you gave them in 2022 and you haven't paid since any rent since June of 2022 or whatever have you. They've been trying to get you out since June of 2022 and you owed money in July of 2022 and you didn't pay anything because the people who didn't pay it because they didn't want to take it from the money from them. They have $900 security deposit. And by all means, they can hold that for the future of January 2024. So you could stay for the whole month of January. What are you talking? That money, that security deposit is done. You owe that in back rent forever and a day. Anyway. Okay. So if the judge does put a monetary judgment against her, the security deposit would not be held unless she said, please apply security deposit to the amount owed, unless the judge ordered, please supply the security deposit to the amount owed. Because obviously, if the judgment is paid in full, then the security deposit would be refunded to her under normal circumstances. I don't see how she has $12,000 to pay, so, whatever. But that's funny. She's like, just take that money and let me stay to January. That money, you pick a month in 2022, pick any month in 2023. That money could account for any one of those months you owe, unless you're going to pay the $12,000 to cover it. Okay, that's why the security deposit is returned to you, is because you pay the judgment and then the security deposit is returned to you. If you don't pay the full judgment, then the security deposit is still held. It goes towards the amount owed. It offsets. That's why the judge will say, apply security deposit to offset this judgment to a certain amount.
Additional help.
Let judge be judge.
But to pay, but they know my circumstances, and
yes, they do. Ms. Gerler. So here's what I'm gonna do. I don't think that there's really much distinction between the 15th and the 31st, and given your circumstances, Ms. Gerler, I'm gonna grant a judgment to the plaintiff for possession. The writ will not issue till January 31st, 2024. There is
Thank you
an
so
issue
much.
regarding, you're welcome, but there is an issue regarding monies that would be owed. And so a trial on any additional monies that will be owed will be set for March 5th, 2024 at 9 a.m. in person. That will give time. The reason I'm setting it out to that date, that will give time by the time she vacates the premises to then you can do the inspection and you can have all of the damages that we can figure out and hopefully have it told. All right. Any questions from
Your
either?
Honor, the only comment that I have to say, and I'm very.
I wonder if she can see the judge's face, because he's talking and she's interrupting and he's holding and counting to 10 so he doesn't explode on her, because she's just.
Very sorry, but I cannot appear in person. I can only appear via remote Zoom.
All right.
Due to my disability.
I understand that, ma'am. All right. Yes, ma'am.
Your Honor, you've struggled getting into for many months now. Since I asked her to leave, pay up or leave from the possession that I filed a few months ago, October. The tenant has not paid us any rent, and she will not let us have access to our mechanical room, which unfortunately is, we have to have access to the mechanical room through her apartment. And we give her notices, and then we have people come, and she will not, oftentimes won't answer the door, or will just say, you know, whatever excuse, and then we have to continually deal with it. That's why I really didn't want to extend the time, but I understand your perspective. It's been very difficult dealing with her. And
this is not great.
Looking forward to this being completed. And I just want to, we do want access to our mechanic.
All right. Under paragraph 10,
Honor?
when you fill out. Yes, Ms. Gerler.
I would like to respond to that, please.
Which part?
The part about them wanting access to their mechanical room, or access to the apartment. I have been subjected to an increasing amount of hostile, threatening, aggressive acts.
I know she was gonna go there. Listen, the you can't harass anybody, blah blah blah. You know that, but the place does not. It is not yours. So if the landlord wants access and you feel like, oh, they're going to be hostile or they're going to threaten me, then you have the right to have someone there to witness and or protect you from whatever hostility you think will incur. But you do not have the right to prevent them from access. You also can say, well, fine, you can have access, but I'm not going to be there. If you don't want to be on site, you don't have to be on site. You just grant them access. You open the door, you walk, you go to the store, or wherever you go, and you allow them to have access. With proper notice, the landlord can have access, regardless if you are in a tenancy, currently paying, and everything is all gravy. The landlord can have access with proper notice. And if you feel like it's hostile and it's threatening and it's illegal, then you call the cops. Get it on record, but don't just come to court and say, well, I don't let them in because they're hostile.
Action, pounding
Okay,
on
Ms.
the
Gerler,
door.
Ms. Gerler, Ms. Gerler.
I would allow them in to do whatever they need to do, but not by myself.
Right, not by yourself. Great, so get somebody there. I would suggest to you, ma'am, your inconvenience is nothing compared to what you have inflicted on these folks. Just my brain. Okay, so that's Squishy's opinion. Yes, this is true. Nevertheless, everybody's convenience has to be accounted for. But the way notice goes, the landlord says, okay, we are giving you 24-hour notice, or 30-day notice, whatever the notices are. We're giving you notice that we need entry. 24-hour notice is usually the the notice for entry for inspection. And you don't even have to say what you want to inspect. We need to inspect the property. We're giving you 24-hour notice. That could be a landlord getting a BPO. They could be getting an appraisal on the property. They could have their real estate agent coming in to determine the valuation of the property, or it could be their contractor coming in to making sure that all of the smoke detectors are still working and that things are proper. And in this case, they say utility room is there, so they need to get to their utility room, which is interesting that you have all of these concerns physically, but the utility room doesn't disturb you being close in proximity. But like I said, I know nothing about what her inflictions are, but they give you a day and time and you just make it available, whether you have a friend come over that day and time, or you just give them the key, or they should have the key anyway. And you say, okay, that works for me. I'm going to be gone during this time. How long are you going to be in the property? Or you have someone come over and witness, or if they're being hostile and they're being threatening, then you call the cops. It's simple. Very
to
simple.
do whatever they need to do, but not by myself, with someone else. I have not resisted them. I have been literally ill when they wanted to come in.
Here's Ms. Gerler, here's what I'm going to do. On the judgment form, when you fill that out at the counter, under paragraph 10, the defendant is to allow plaintiff access to the mechanical room upon 48 hours notice.
Okay, 48-hour notice.
Ms. Gerler, that will give you time to get somebody there.
Yep.
That's adequate notice that if you're going to have somebody else go in and look, you got the time to do it.
Your Honor, that is totally fair, and
thank you. That's what I do.
I'm very impressed with you, Your Honor, so thank you.
Well, thank you, Ms. Gerler. I appreciate that.
Will you put that in writing, or do I need to?
You need to write that under paragraph 10 on the judgment form when you pick one up the front.
Okay. And what exactly do I have to say again?
Defendant, you know what? Go fill out the judgment form. I'll put it under paragraph 10. I got it. Okay.
I actually have it filled out, but this, it wasn't just for possession. This was.
There's a money portion of it too.
Which is important.
It's you wanted possession and you want a money judgment, or
so I can give you both of those.
You can give me the judgment form. The money judgment piece I've adjourned to March.
Okay, so then I don't fill out the money piece. All the rest is.
Do you have the?
I have a form. I didn't expect it.
Okay. Put the names on there. I'll fill the rest out.
Okay.
All right.
Judge is like, I'll take the homework.
Thank you.
Need the homework so we can get it done right.
Thank you, Ms. Gerler, and both of you have a very happy holiday.
All right. Okay. So there's that. There is that. Interesting enough. So okay, we're still recording. Sorry. I was trying to see if Old Squishy Garden had an update. I don't see one, but bottom line is she got to move. Okay, so hopefully she did. By now, I'm sure she has. We learned a couple of things. What did we learn? Every problem we have is not someone else's problem. Even though we can have empathy and sympathy for another person, does not mean that you don't have to get out. Everyone has the right to their own possessions. And so just think of it for yourself. If you're the owner of a property and you want someone out and they have physical ailments, you may have a heart for them and say, okay, I understand you have physical ailments. But like she said, I've been telling you for over a year to get out. Like I've given you all the time that I possibly can, if not more, to move, to make a plan to move. And the solutions you came up with did not resolve the back pay, did not resolve the rent owed. So you physically need to move. Okay. So when we're a tenant, it is always good to talk to the landlord. Work it out as much as you can. Don't let it escalate to court. Obviously, want to deal with things when they're as small as possible. You don't want it to escalate to court because now it goes on your record and it becomes a problem when you're trying to get a loan or sometimes a job, depending on what kind of job. And especially if you're trying to get another location, they see an eviction on your record, that becomes an issue. So you don't want to have to resolve in court. You would love to resolve outside of court. So try that. Try that as your first measurement and your first attempt. But nonetheless, we've learned a lot. We have great fun. Thank you, Old Squishy Garden, for making that available to us. And thank you to Judge Simpson for always, giving it to us real, and for his calm demeanor to listen to all sides and come up with a resolution. I personally would not have been okay with the end of January, but that's just my personal thing. I'm not the judge, so that's me. So who cares what I got to say, right? All right, good job. Hope you are having a good one. Love on someone, be loved by the right one, and have a great day, okay? Appreciate you. Lyric Armstrong here, your real estate agent advocate. Until the next video.